Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. Today we're going to explain the Illinois civil appeals process. We'll start by explaining basically how the court system works in Illinois very briefly, and then we'll go over everything you need to know about the Illinois appeals process. This is going to be kind of one of our Appeals 101 episodes that's going to go into a pretty good depth, but we have an article on the subject associated with the video at learn-about-law.com that's going to lay out a lot of the things we talk about in a lot more detail. So without further ado, let's explain how the Illinois court system works so we can then go into appeals. So first of all, there's state court and federal court, and depending on what kind of claim you have, you may have the choice to file in either or both. Sometimes you have to file in federal court, sometimes you have to file in state court. But the state, on the state level, they have their own appellate court and Supreme Court. But what we'll start with is the circuit court. The circuit court is where cases began, where they're initially filed, and each county has its own circuit court. So there's a DuPage County Circuit Court, there's a Cook County Circuit Court, and these are called trial courts because this is where evidence is presented to the judge or the jury, and then the judge and jury hold trials to determine which facts they believe based on the evidence that's presented to them. So this is where findings of fact are made. And this is where cases kind of go on for sometimes a number of years because all of the motions before trial about what evidence is presentable to the judge, what evidence is discoverable, all of these motions happen on the trial court level. Then once a judgment is entered or certain types of orders other than judgments, these judgments or orders can be appealed to the appellate court. The appellate court doesn't do any factual findings. They basically just look at the record of the trial court. They everything that's been filed in the case, transcripts of any hearings, and any evidence that's presented, as well as new briefs that the parties write to the appellate court, and sometimes new oral arguments, and they make a decision on whether to reverse or affirm the trial court's findings, or they can do something called remand it back to the court to have them take some further action. So once the appellate court rules, then the parties can, if they disagree with the appellate court's ruling, they can appeal to the Supreme Court of Illinois. But unlike the appellate court, the Supreme Court doesn't have to take their case. The Supreme Court basically takes whichever cases it wants to, mostly based on public policy. So for most people, the appellate court is kind of the last arbiter of the law, because getting your case taken by the Supreme Court is kind of a rare thing. So that's how the court system works. Now let's talk about what sort of orders are appealable, because you can't appeal everything. There's a lot of orders that happen during the pendency of the case in trial court, between the time the case is filed and the time that there's a final judgment at trial, that are not appealable. But some of those intermediate things are. So we're going to talk about what's appealable and what's not. It's basically being ripe for appeal. Being, if it's not ripe for appeal, the appellate court won't hear it. So first of all, the baseline rule is that final judgments as to all parties and all claims, basically the end of the case after trial, those are appealable. Those are automatically appealable. And that's what it sounds like, because in a lot of cases there's multiple parties, multiple claims against the same party, and once those are all resolved, then the case is appealable. Partial judgments are also appealable if the judge basically specifically contains language in the judge's order saying that they're appealable. So let's unpack this a little bit. A partial judgment is a judgment on one or multiple, but not all of the claims in the case, or against or a judgment relating to one party but not all of the parties. So it resolves some of the issues in the case, but not all of the issues. And this can happen before trial through a motion to dismiss or a motion for summary judgment. And once these partial judgments happen, those aren't automatically appealable like a final judgment as to all of the claims and all of the parties. Partial judgments are appealable according to Illinois Supreme Court Rule 304A if the judge explicitly states that there's no just reason for delaying the appeal of the judgment or the enforcement of the judgment. If the judge includes that language in the judgment order or in a later order, after a motion by the parties to have that language included, then that partial judgment becomes appealable. So far we've dealt with all judgments as to all the parties and all the claims, partial judgments as to some of the claims or some of the parties. And now let's talk about interlocutory appeals. So interlocutory is a $10 word for orders that occur before. They're not final judgment orders. They're orders throughout the course of the case that are not finally resolving any of the claims. So that's called an interlocutory order. These are not automatically appealable unless they're of a certain type. There's certain types of interlocutory orders that you can automatically appeal, and we'll talk about some of those. And there's other types of interlocutory orders that can be appealed with the permission of the appellate court, so you have to file a petition. Let's talk about the ones that are appealable as of right first. There's a statutory list that we go into in some detail in the article on the subject that lays out types of interlocutory orders that you can automatically appeal. I'll hit on some of the high points right now. So certain types of orders dealing with motions to dismiss based on the forum or venue in which the case is filed or the jurisdiction of the court are automatically appealable, even though they're not a final judgment on the merits. Orders impacting the custody and care of children or the allocation of parental responsibility or the relocation of minor children are automatically appealable as of right, even if they're not a final order. So even temporary orders that deal with that can be appealable. Orders granting a motion to disqualify one of the party's attorneys are automatically appealable, and orders granting or denying the certification of a case as a class action. There's a couple others on the list, but those are kind of the ones that are more common. So those interlocutory orders, again, they're not a final judgment on the merits, so they're not automatically appealable according to our general rule, but there's exceptions for these specific types of orders that are automatically appealable. So now let's talk about interlocutory orders that are appealable by permission. So the rule of thumb is, again, final judgments, as all the claims are always appealable. Intermediary orders as a baseline are not appealable. We've got our statutory exceptions that are automatically appealable, but now there's a list of exceptions that are appealable but not automatically. You have to actually file a petition with the appellate court in order to appeal these types of orders. The appellate court can choose to grant or deny that petition, and kind of like the Supreme Court all the time, can choose whether or not to hear that case. So what we have a long list at learn-about-law.com about what types of orders are appealable by permission of the appellate court. I'll hit on some of the highlights. Most orders dealing with injunction. So an injunction is the court basically ordering you to do or not do something other than pay monetary damage. Most orders granting, denying, modifying, or dissolving injunctions are appealable by permission. So you have to actually file a petition and get the permission of the appellate court to appeal them. Orders terminating parental rights are appealable by permission. So there's more, but the rest of the lists aren't terribly interesting to most people. But you get the idea. There's four basically classes of types of orders that are appealable. Final judgments as to all claims and all parties, always appealable. Partial judgments, appealable if there's special language included in the order. Interlocutory appeals fall into one of three classes. They're either statutorily automatically appealable, they are on a statutory list that they're appealable by permission, and if they don't fall into one of those two classes, the third class, and the general rule is that interlocutory orders or orders that happen in the middle of the case are not appealable. So next, let's talk about the deadline to file the appeal. This is a pretty strict deadline, so you want to make sure you understand what type of case you have and where the deadline falls for you. So the general rule is that for final orders as to all claims against all parties, these are appealable within 30 days of the judgment. So you have to file your notice of appeal within 30 days. There's several exceptions to that, and we'll go over that. So the first is if there are any pending post-judgment motions that will affect the judgment itself, then the clock starts ticking from the resolution of those post-judgment motions. Second, if there are any outstanding sanctions claims that the court is deciding. So one of the parties is seeking fines against one of the other parties or attorneys based on their behavior during the case. Those outstanding sanctions claims toll or extend the deadline to file your appeal. Interlocutory appeals as of right. So those statutory appeals we talked about earlier that are automatically appealable, those statutory orders that are automatically appealable, the clock starts ticking from the time the order is entered, not from the final resolution of the case. So if you're in one of those statutory categories that your order is automatically appealable, you have to appeal it within 30 days of the order, not the conclusion of the case. Similarly, for partial final judgments, as to certain claims, certain parties, but not all claims, not all parties, those partial final judgments in which the court explicitly says there's no just reason for enforcement or delay in enforcement or appeal. Those types of partial final orders with that explicit language must be appealed within 30 days of the order containing that language. Finally, the last exception is if you blow your 30-day deadline based on any of these different situations. If the 30 days passes, and within the next 30 days you file a motion for extension of time and can show just a reasonable cause for your failure to meet the deadline, then the court has discretion to allow you to file within the second 30-day period. All right, so next let's talk about the process for filing an appeal. We're going to talk in broad terms. This is highly technical. You should definitely have an attorney do it. Don't try to do it yourself. Again, we have a little bit more detail on our website on the article associated with this video. But what's the process for filing an appeal? So the first thing you do is you file a notice of appeal, and it's a very specific form, with the circuit court, the trial court, the court where that entered the order that you're appealing. And we already talked about the deadlines for when that has to be filed. So that's the thing that starts the clock on everything else. Once the notice of appeal is filed, you have 7 days to file with the appellate court a notice that notice of appeal has been filed. Then within 14 days after the notice of appeal has been filed, you have to file a docketing statement with the appellate court. And what a docketing statement is, it's basically some general information about the case for the appellate court. And during this entire process, you should be working with the circuit court to compile something called a record on appeal. A record on appeal consists of the order that you're appealing, the notice of appeal, everything that's been filed in the case, all of the orders that have been entered in the case, all of the evidence that's been submitted in the case, and transcripts of any hearings that have happened in the case. So it's on the appellant, the person that's actually making the appeal, to work with the circuit court to compile this. So a couple things you do. You submit a form to the circuit court asking them to compile the record on appeal on their end, and then you also contact any court reporters that have been involved and ask them for transcripts, and you deliver that to the circuit court. The circuit court will then prepare the record on appeal, and there's several deadlines associated with this process, but at the end of the process, you coordinate with the circuit court as the appellant to deliver the record on appeal to the appellate court. And sometimes you can pay a fee, and the circuit court will do this directly. You can do it by hand yourself if you want. But that's basically the process, the key steps that go into filing the appeal. So you file the notice of appeal with the circuit court, you file notice with the appellate court, you file a docketing statement with the appellate court, and then you work with the circuit court to prepare the record on appeal that the appellate court will be working off of, and then deliver that to the appellate court. So let's next talk about what happens after an appeal is filed. What's the process for having your appeal heard? Unlike the circuit court, where there's motion practice back and forth, there's discovery, there's a lot of stuff going on, the appeal process is pretty straightforward. So once the appeal has been filed and the circuit court has the record on appeal, there's a 35-day deadline for the appellant to the person making the appeal to file a brief. The brief basically lays out the argument of the appellant and why the appellant thinks that the order that is being appealed should be overturned. Then the appellee, the person on the other side of the case, files a brief responding to the appellant's brief. Then after that's been filed, the appellant files a reply brief responding to the response. So 3 briefs are filed. The appellant files the first one, then the appellee replies, and then the appellant files the 3rd brief. And a lot of times this is once these 3 briefs are filed, and the court will just look at these and the record on appeal and make a decision and issue an order. There's not necessarily any oral argument that happens. But sometimes after reviewing the briefs, the court will want to hear oral argument from the attorney. So in that case, the court will notify both sides that there's going to be an oral argument, schedule it, and the attorneys will go in and answer questions from the appellate court or argue their case verbally to the court. So in any case, whether or not there's an oral argument, once the briefs, the record on appeal, and the optional oral argument have happened, then the court issues an order and makes a decision. So what actions can the court take? There's basically 3 things the court can do. One is affirm the ruling of the lower court. So the appellate court can say, we agree with the lower court's ruling, and in that case, the appellant loses. And that's the final word on the subject unless further appeal is taken to the Supreme Court. The next thing, or another thing that the appellate court can do is reverse the lower court's ruling. So this means that we're overturning the ruling, the appellant wins. Basically, the opposite of whatever the lower court ruled is what's going to happen, and that's the final word on the subject unless the appellee then appeals again to the Supreme Court. The last thing that the appellate court can do is remand to the lower court, and remand is basically saying something went wrong on the lower court level, or we disagree with something that happened, or there was new evidence or new law that came out after the original ruling. So trial court, we want you to have a new hearing, we want you to do such and such additional things, and then there will be a new ruling, and then it can come back up to the appellate court at that point if someone appeals that new ruling. So one of those 3 things, or sometimes a combination. Sometimes the appellate court will reverse the ruling and remand and ask for further hearing to be had at the lower court level. So next, let's talk about the enforcement of judgments while the appeal is pending. Money judgments and injunctions are treated differently. Money judgments are what you would expect them to be. They're orders to pay a certain amount of money to the plaintiff. Non-monetary judgments, usually injunctions, are orders for the defendant to do or to not do something. Let's talk about money judgments first. Money judgments will be stayed, meaning that they're placed on hold. They don't have to be paid, can't be enforced until the pendency of the appeal if the defendant files a notice of appeal on time and files also an appeal bond or some other form of security that's acceptable to the court. That's basically insurance, making sure that they don't dissipate the funds that would be payable in that judgment during the pendency of the appeal. So if you do an acceptable appeal bond and a notice of appeal, then your money judgment will be stayed during the pendency of the appeal. Let's talk about injunctions. Injunctions aren't automatically put on hold during the appeal. The person seeking to put the injunction on hold has to file a motion with the circuit court and have a hearing where both sides may brief the hearing and present oral argument. And after motion and a hearing, then the circuit court has the discretion on whether to put the injunction on hold or stay it. The process is that you have to file this with the circuit court, the lower court, first. You can't directly go to the appellate court to have these enforcement actions stayed. The exception is you can go directly to the appellate court in certain situations. You have to show that it's not practical to go to the circuit court to get the stay of the judgment that you're looking for, or that the circuit court has already denied your application to stay the enforcement of the judgment, or the similar relief that you're requesting in your stay of enforcement. Some types of orders that terminate parental rights are automatically stayed on a limited basis without the need for petition and without the requirement for a bond. So what are your options if you lose on appeal, if the appellate court rules against you? You basically have 3 options. First, you can let the appellate court's decision stand as the final ruling on the case. Not a great option. Second is you can file a petition for rehearing at the appellate level. These petitions are basically asking the court to reconsider their judgment. They have to be filed within 21 days of the appellate court's order. And they're really only going to be accepted if you can show that the court misunderstood fact or law when it was making its judgment, or that new legal authority has been issued since argument was made on this case. New legal authority is the most likely way that you can get one of these petitions heard. Misstatement of fact or law, misunderstanding of fact or law is not a very likely way to get your petition reheard, but there's a chance of doing so. After this is done, or simultaneously, you can file a petition for leave to appeal to the Supreme Court. And again, the Supreme Court doesn't have to accept your petition. It doesn't have to hear your case. The petition for leave to appeal has to be filed within 35 days of the appellate court's order. If you're filing a petition for rehearing at the appellate level, it can be filed within 35 days of the order on the petition for rehearing. The Supreme Court, again, doesn't hear a whole lot of cases, doesn't hear high percentages, about 2% to 4%, depending on the year. But you're more likely to have your case heard if on the appellate level there was a dissent, so there's a disagreement among the judges on the appellate level. If the appellate court's opinion is in conflict with other divisions of the state appellate court, so there's multiple divisions of the appellate court, your division might rule something that's in conflict with the other divisions. They don't have any obligation to follow the other division's holdings. If there's a conflict within the state, you're much more likely to have the Supreme Court hear your case. Or if the issue you are appealing has broad legal implications outside of the particular set of facts that you're dealing with, or major public policy implications. So again, your three options are: let the order stand, ask the appellate court to reconsider their judgment, or appeal to the Supreme Court, or file a petition for leave to appeal to the Supreme Court. So thanks so much for listening. I hope this answers your questions. There's a lot more detail at learn-about-law.com in the article associated with this topic. We also have lots of other videos and articles on nearly every subject of law. Thanks again.
Thanks for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit makingrealestatefun.com for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation. Thanks for watching.